Sorry to keep all of you waiting. Actually, both Justice Khanna and I were in a meeting with the members of the bar, senior advocates designation. So there's something very important to the bar. So yeah, just the preliminary groundwork which has to be done.
This point one must ask for a trade-off, as I mentioned earlier. But I'm very fearful of that. Because when we were arguing 370, they gave me water and I said, whiskey? And I got calls from Singapore and all over India. Was there whiskey in the glass or not? Now, my lord, I want to take your lordships to the statement of objects and reasons. I'm still on the purpose point, which is in volume 4A.
Submissions really look at, please have a seat. Please have a seat, doctor.
No.
Look at the antecedent history of the institution, one, the purpose of the statute, and place the provisions of the statute in the backdrop of the antecedent history and its purpose. And the mere fact that a statutory provision somehow restricts what a minority institution could otherwise do in the absence of the statute would not be a ground to deny its status in an Article 30 institution.
That's the point about recognition also.
And recognition and affiliation.
Yes.
You have to apply according to you for recognition, otherwise your degrees will never be recognized.
Even for schools, where they depend on aid.
That's the submission, really.
Even there.
Colleges too.
Colleges. In fact, the whole part of Inamdar relates to aided and unaided. That the unaided don't lose their minority character. I sit down with
Yeah, yes, Doctor.
I'm very sorry. I'm very
No,
touched.
please have a.
Volume 4A, my lord, page 88.
You were reading actually volume 1A, page 60, I think.
I'll come back to that.
Okay.
I'll come back to that.
So we look at volume
4A at page 88. Your lordships have it.
Yes.
Now, this is the statement of objects and reasons to the 1920 Act.
Yeah.
4A. That's right. Lord, the printed version is on 87. This is easier to read because it shows the nexus, my Lord, that I was talking about. The Muslim University Association, having requested the foundation of a university and certain funds and properties being available to this end, it was proposed to dissolve the association and the Mohammedan Anglo-Oriental College, Aligarh, and to transfer the property of those societies to a new body called the Aligarh Muslim University. The present bill is designed to incorporate this university, to indicate its functions, to create its bodies, and to define its functions. It also secures the university's assurance of a permanent endowment to the government.
And the necessary
Part of control. The university and the teaching residential type, in accordance with the recommendations of the Calcutta University Commission, the university will not include intermediate classes, but the university will have the power to maintain establish and maintain intermediate colleges and schools at Aligarh. They're all Muslim. The degrees conferred will be recognized by the government. Special features of the university will be imparting for Muslim religious education to Muslims and the inclusion of the Department of Islamic Studies. The bill provides for the making three. The general terms, my Lord, on page 89 of the bill and statutes have at various times been discussed with the representatives of the Muslim University Association. That's the purpose. Now, my Lord, I'll come to my written submission, my Lord. I'll flag that very much. I have, my Lord, in my summary, what the reference is really about. I've given a short paragraph and then
60 of your written submissions.
this is my written submission.
Also, when we use the expression, Article 30 uses the expression establish and administer.
Yes.
Now, there is no absolute standard of administration that you must administer 100%, and even that 100% will be an elusive standard.
Right.
So, to make Article 30 effective, we do not have to postulate that the administration by the minority has to be an absolute administration. In that sense, today, in a regulated society, in a regulated state, nothing is absolute. virtually every aspect of life is regulated in some way or the other. So merely because the right to administer is regulated by statute and to a certain extent is not untrammeled, does not detract from the minority character of the institution.
That's the point we were making. I'm grateful. But that is the essential point. And then you add of their choice.
Of their choice. And it's established means you must have founded it, as you said.
Right.
And that is a little more objective, but administration in that sense, there's no statutory definition or constitutional definition of the expression administer. Yes, the courts have held what administration means. But if that right of administration is regulated itself by statute,
Lord, it can't be that it'll all be Muslim, Muslim, Muslim. It just simply cannot be. Because after the Constitution, all the universities have a liberal element in them. Please give representation to students, representation to teachers. All that is there, my lord, in our university statutes.
three things are very clear. You don't have to be administering only religious courses. You can be administering a purely secular education institution.
That's right.
That's one. Second, the law is not that you have to admit only students of your community. You can admit students of all communities without forsaking, because it's a right of establishment and administration. So that's the second important ingredient. And therefore, a minority institution does not lose that character according to your submission merely because various aspects of its existence are regulated by statute, including aspects relating to the administration of the institution.
Right.
The state in public interest is entitled to regulate, or the state legislature or parliament, as the case may be, is entitled to regulate administration in public interest to ensure that the conditions of service of the teachers are fair, that the staff of the institution is not maltreated or not deprived of basic conditions of service. There'll be a variety of administrative requirements which the state can impose, or the minimum requirements for the allotment, for the conferment of degrees, standards of examination, standards of syllabus, the curriculum. That's all regulated by the state, but that does not detract from because that applies across the board, irrespective of whether you are a minority or a non-minority institution.
That's right. And that's why I said in the beginning, we accept that it must be institutions of excellence and all the other regulatory features, statutes must apply. With one caveat, my lord, which is repeated again and again, that the right to administer does not mean the right to maladminister. That's very important. It comes in Kerala education and then, of course, my lord, in TMFI. Just, my lord, to get this purpose, etc. point dealt with, my lord, page 60. Because in our respectful view, the reference has to be culled out by your lordships. Because it mentions the Minority Act, it mentions the University Act indirectly. So all that has to be culled out. We've said, was Aziz Bhasha right in accepting the antecedent historical data on AMU's Muslim character, but denying its constitutional significance while deciding the issue of its minority status, which is at variance with St. Stephen's, Proust, and Path? Because they recognize, my lord, the antecedent history and just give it the go-by. Because that point about nexus and continuity, my lord. Origins. What is the origin? In St. Stephen's, they go right through the origins and they even say, you look at the buildings and they are quite clearly Christian in character. Now, my lord,
just one thing. This you are raising it in the context of Aligarh Muslim University. What will be the position post the enactment and enforcement of the Constitution?
yes, my lord, of course.
With regard to universities which are established or founded thereafter?
My lord, what we have seen is that a large number of deemed universities under the UGC Act and the other statutes, they've been declared to be minority institutions despite Aziz Bhasha. And therefore, my lord, we have to look at this now also, as I will point, through the constitutional lens, which is the question your lordship put to me on Article 30. And my lord, liberal education has to be combined with religious education. May I proceed now?
Yes.
60, my lord. I have dealt with this, but just to, as a preface to the next argument, the Mohammedan Anglo-Oriental College was the nucleus of the appellant university. This is what Basha says. The founders had from the very beginning desired to incorporate MO colleges as a university and grant degrees that are recognized by the government. The Muslim community largely contributed the funds necessary to incorporate MAO into a university. The founders had long negotiations with the government to introduce a legislation and establish the MAO college. Nonetheless, both courts have held now in Allahabad that the appellant university was not a Muslim university. The word establishment, my lord, is followed almost mechanically. Now come, my lord, to the antecedent history. I'll run through it very, very fast. I realize time is of the essence. Now, my lord, come to 61. We have divided, my lord, the antecedent history into three phases. From 70 to 77, where the earlier idea of setting up a university for the Muslim community for the betterment and advancement took place, and when MAO college was established. From 77 to 1910, the Muslim community rallied to convert MAO university, and due to their efforts, the government in principle agreed to convert the college. And from 1910 to 1920, where the founders from the Muslim university actively engaged with the government and succeeded in their desire to convert and incorporate the MAO college. Now, my lord, the vision, my lord, in the first phase, I'll just quickly run through it, my lord, your lordships may read it through because I don't want to go too much. In the first phase, my lord, in 1870, Sir Syed established a committee for the better diffusion and advancement of learning amongst Mohammedans. The committee sought the views of the Muslim community as to why the Muslims were not availing Western education, and it was found that this was due inter alia lack of religious education, non-consultation with minority Muslims. Thus, the idea of an educational institution managed by Muslims for the benefit of Muslims with religious instruction received support. Then 1871, my lord, the MAO college is established. Over the page in 62, when the committee says, the object of the committee shall be to collect funds towards the establishment of the college, particularly one for the education of the Mohammedans as suggested by the Central Committee for better diffusion and advancement of learning amongst Mohammedans. Now, my lord, the committee resolved to establish the Madrasa Ulum, madrasa being a term for education at Aligarh, which was subsequently inaugurated. This was the first step realizing the vision of a university. Then, my lord, the Madrasa established the MAO college. And then, my lord, I'll just say what the Governor General says. From the seed which we sow today may spring a mighty decree whose branches like the banyan of the soil shall in their turn strike firm roots into the earth and send forth the new vigorous sapling. That is, the college may expand into a university. So this is the other element, my lord. As your lordship pointed out, it's not just Muslim education, it has to be more than that. And after the constitution, certainly so. Then, my lord, rules and regulations of MAO say object to the college shall be primarily the education of Mohammedans. Then first only the Muslim community was involved in the administration. And I mentioned the select committee and the rules for guidance of the MAO college. Over the page, my lord. The second phase, my lord, consists of the Syed 7.6.1, seeking the government's support for the Muslim community and looking upon a degree as a means to success and government jobs as recorded by Altaf Hussain Hali in his biography of Sir. In further, my lord, of the written address was presented to the college fund committee to the viceroy. By far the greater portion of your funds and endowments naturally derived from members of your race and creed. Someday when our endowments are richer and our schemes are completed, we hope to ask to confer upon us the legal status of an independent university. The funds, my lord, come from. Then, my lord, there's recorded in this book, my lord, in 1998, a memorial fund was created to raise funds for incorporating MAO College, and this proved to be a success. 1,27,000, my lord, was an enormous amount in those days. I remember, my lord, my amount we used to get, my lord, in my school was only 2 rupees per week. It was huge. So we have got to inflation-proof this. Now, my lord, at the bottom of that page, those and other efforts by the Muslim community resulted in substantial funds collected for the establishment of the university. Then, my lord, there was an address that was given when they met the viceroy. His ideals and those of Sir Syed with regard to the expansion of the colleges are the view is the ultimate development for the formation of a Mohammedan university, of which the idea was strongly supported by the late Justice Mahmood, son of Sir Syed, and by Morrison, our last principal. The former may be indeed to have said to have formulated, if not fathered, the university scheme, while the latter developed it in numerous writings. Now, this is the great Justice Mahmood, my lord. As your lordship knows, the Privy Council saw his judgments and said, you please become High Court judge. After that, he delivered, I think, 8 significant judgments, and then he resigned to get himself involved, my lord, in this process. Now, my lord, we come to the third phase, which is important. In 1911, the Committee Takmili Mohammedan University Foundation Committee, now this is important, was constituted for converting MAO College into a Muslim university with the Raja Sahab of Mahmoodabad as the president. On the recommendation of the Government of India dated 1911, the Secretary of State approved in principle the establishment of a university at Aligarh, subject to provisions of adequate funds and control. 1911 again, the Government of India specified that a university could be established only through a bill in the Legislative Council. Over the page, my lord. Then, my lord, in 1911, page 65, or rather PDF 65, where an institution styled as Mohammedan Oriental College was founded by Aligarh in 1875 under the leadership of Sir Syed Ahmad Khan Bahadur, with the special object of promoting the diffusion of Western science and literature and of training the character of students by a scheme adapted to meet the special requirements of the Muslim community. Both, my lord, a liberal education as well as, my lord, the demands of the Muslim community. And whereas from the beginning, the object of the founder and the Muslim community was to raise such college to the status of a university, whereas a memorial had been presented to the government by the trustees of the said college and other representatives of the Muslim community, praying for the erection of a Muslim university and inviting attention to the advantages a university would have, which would confer on their community to the inadequate representation of which their community had in existing, to the enthusiasm which their own university would create amongst the Muslims. And then, my lord, and to the need for religious teaching and protection. So, my lord, the fact, as was pointed out in an interruption, that MAO College could still get degrees, that's not the only point, my lord. The point is of substance, a liberal education along with the concerns of the Muslim community. Then, my lord, 1911, the Secretary of State says sanctioning a university at Aligarh will be a source of enlightenment and prosperity that the Muslim community and will crown and continue the hopes of Sir Syed Ahmad Khan. The negotiations continued, my lord, and then your lordships will see that 5 lines from the bottom on 65, in an intervening letter dated 9/10/1912, The education members specifically mentioned that the movement was started without reference to government and that the hope of Sir Syed to convert Aligarh into a teaching and residential university, and his hope has been repeatedly expressed since the leading Mohammedans and others are connected with the college. Also note that the draft constitution stated from the beginning the object of the founder and the Muslim community was to raise the college to the status of a university. 1915, my lord, practical shape was given to this, and the MAO annual report, I won't read it, my lord, and it says the conversion should be there. Then, my lord, 8 is important on page 66. The Muslim community raised 30 lakhs for the university as required by the government. So this is the interaction, my lord, the money was raised by the Muslim community. And this, my lord, you find reference in the statute and in Section 7. Now, my lord, after extended negotiations, the Muslim University Bill was prepared in 1990, referred to the Select Committee. The Select Committee report submitted its report to 2/9/19 at 2nd of September. The Muslim community's predominant role in the university administration is clear from the debates. In reference to the constitution of the court, we have retained the provision that no person other than Muslim shall be members. We have done this because we understand such a provision is in accordance with the preponderance of Muslim feeling. Then, my lord, the matter comes to the Legislative Council. Before putting the question, I would like to add congratulations to the Muslim community on the passage of the bill. I've come specially this morning to preside that I may add good wishes, etc. Then, my lord, the University Act of 1920 was a statement of objects and reasons, which I've read to your lordships, my lord. My lord, it's just not the degree, as they said you could do it before 1920. It's a wholesome university with liberal education and the concerns of Muslim theology, etc. Now, all this, what Aziz Bhasha does, it says that in the Select Committee, there was some disagreement on this. That's not how to read a Select Committee, my lord. I pointed that out to your lordships. Now, my lord, I 7.8 is just important because, my lord, your lordship doesn't look just at the de jure situation, also the de facto. And this we have pointed out that the members of the first court were Muslim, 8 to 12 members were Muslim, every chancellor to date has been Muslim, 34 out of 37 vice chancellors have been Muslim. The vast majority of the members of the court, executive council, academic council, and executive council, my lord, have all been throughout Muslims. Now you want to take all that away, because when appointments were made by the government, they made sure that the appointments conform to the Muslim character. Then, my lord, I have already read because St. Stephen's looks at the emblems, my lord, there. I just want to do 7.9. My lord, when this was argued in Allahabad, Siddharth Shankar Ray, my lord, gave 3 volumes, and the court said, yes, of course it is Muslim in appearance, but we are bound by Aziz Bhasha. Now, the history background is architecture of the building, such as a deep green color, Quranic inscription, clearly show the Islamic character. Photos were shown to evidence to the division bench. The emblem of ANU contains a Quranic verse. The university has a university mosque. After the amendment was allowed to establish halls, hostels, special centers, specialized laboratories, only within 25 kilometers of the university mosque. The university employs muezzins. At its inception, the MAU had departments of study, Sunni theology, Islamic studies, Persian and Urdu, studies for Islamic medicine, all that I've read to your lordships. I don't need to read it further. Now, all these documents, my lord, are in there. I don't want to take your lordships further. I've just summarized them. And to answer the argument sort of raised. It's just degrees. You could have done it before. No, you wanted a university. You wanted a liberal education. I've done the face now. Unless somebody, he seems to be. Your lordships point it can't be full and complete control. It can't, my lord, especially after the constitution. And administer, my lord, has to be considered. Now, my lord, I'll read some judgments, my lord, including TMA Pi and Mother Provincial. This your lordships will find in volume 5A. This will answer, my Lord Justice Khanna's question to some extent. Pre-constitution, post-constitution, the change and the requirements. Now, my Lord, Kerala Education Bill, I'll be in 5A, I'll be very fast, my Lord. Starts at page 4, but I'll go straight, my Lord, to 71. I'm sorry, my Lord. I missed out, my Lord, on page 60. That is, my Lord, somewhere halfway down. There is no reason why the benefit of Article 31 should be limited only to educational institutions established after the commencement of the Constitution. The language employed in 31 is wide enough to cover both pre-Constitution and post-Constitution institutions. Then, my Lord, 61 is very important, my Lord. This is about 15 lines from the top. The sentence beginning, to say that an institution which receives aid on account of its being a minority educational institution must not refuse to admit any members of the other community only on the grounds therein mentioned, and then to say that as soon as such an institution admits such an outsider, it will cease to be a minority instrument, is tantamount to saying that minority institutions will not, as minority institutions, be entitled to aid. Now comes the important part. The real import of Article 29(2) and 31 seems to be that it clearly contemplates a minority institution with a sprinkling of outsiders. Let me pause here, admitted to it. My Lord, that sprinkling now after St. Stephen's has gone up to 40%. So St. Stephen says you can go to that extent. And of course, my Lord, this is modified by TMA Pi says it may not be 50%, it will depend on the needs of the institution. Then, my lord, by admitting a non-member into the minority institution does not shed its character and cease to be a minority institution. Indeed, the object of the conservation of distinct language, script, culture of a minority may be better served by propagating the same amongst non-members of the particular community. In our opinion, it is not possible to read this condition into Article 30, subclause 1. Then, my lord, page 62. Comes the important, my lord, pronouncement of the words of their choice. This is, my lord, just below halfway. My lord, I'll go just halfway down. The key to the understanding of the true meaning and implication of the article under consideration are the words, as your lordship got it, of their choice. It is said that the dominant word is choice, and the content of that article is as wide as the choice of the particular minority may make it. The ambit of the rights conferred by Article 31, therefore, have to be determined. It should be referred to be determined on misprint by Article 31, and therefore to be determined on has therefore to be determined on a consideration of the matter from the point of view of the educational institution. Now, all this, my lord, somehow Kerala Education Bill was before Bhasha. The foundation had been laid here. And the analysis of Article 31 is missing, my lord, in Aziz Bhasha. It just goes by established or administered, doesn't look at the question of choice. Now, Kerala is a 7-judge, my lord, decision, binding, my lord, on TMA Pi for the interpretation of 30. Now, my lord, 71. This is halfway down, my lord, because now, my lord, where it begins, we have already observed that Article 31 gives 2 rights to the minorities to establish and to administer educational institutions of their choice. The right to administer cannot obviously include the right to maladminister. The minority cannot surely ask for aid or recognition for an educational institution run by them in unhealthy surroundings without any competent teachers possessing any semblance of qualification, and which does not maintain even a fair standard of teaching, and with teaching matters subversive of the welfare of the scholars. It stands to reason that the constitutional right to administer an educational institution of their choice doesn't necessarily militate against the claim of the state to insist that in order to get grant, the state may prescribe reasonable regulations to ensure the excellence of the institution to be aided. Learned Advocate General, Attorney General conceded that reasonable regulation may certainly be imposed. So both aspects, my lord, excellence, these are not ghettos, my lord, excellence and application of the general law. Then, my lord, if your lordship will come to 72. It says, my lord, at the top of 72, what the state says, I have money and I shall distribute it, but I shall not give you any of the, unless you surrender to me your right of administration. Then the state must not grant aid in such manner as will take away the fundamental right of the minority community under Article 30. Then, my lord, about 1/3 from the bottom. No educational institution can in actual practice be carried out without aid from the state. And if they will not get it unless they surrender their, unless they surrender their rights, they will by compulsion of financial necessity, they will be by Yeah,
They will be compelled to give up.
they will be compelled to give up their rights. So, my lord, this whole question of recognition, aid, you don't surrender rights. 76. This comes to the question of recognition, my lord. Aziz Bhasha says, look at the section 6. They're saying recognition, that's by the state. Now, my lord, about just last 1/3.
Commander is willing to desire the education.
ठीक है ठीक है निखिल. I'll go straight to the recognition point. Then, my lord, about just below halfway, without recognition. Aziz Pasha says you got recognition from the state, therefore you surrendered your rights. In a sense, it's implying that. Without recognition, therefore, the educational minorities established or to be established by the minority communities cannot fulfill the real objects of their choice, and the rights under Article 30 cannot be effectively exercised. The right to establish national educational institutions of their choice must mean the right to education, right to establish real institutions which will effectively serve the needs of their community and the scholars who resort to their institution. There is no doubt that there is no such thing as a fundamental right to recognition by the state. But to deny recognition to educational institutions, except upon terms tantamount to the surrender of their constitutional right of administration and their constitutional right of administration, where are we? Of
Administration of the educational institution.
Of the educational institutions of their choice,
Is in truth.
and is in effect to deprive them of their rights under Article 30. The word recognition in the 1920 Act can't be read as something that the government gave you, but it is your right. It can't take it away. And it's quite clear here. We repeat that the legislative power is subject to fundamental rights, and the legislator indirectly take away and abridge the rights which it could not do directly, and yet will be the result of the said bill containing any offending clause becomes law. Now, my lords, this, my lord, is the foundation of the interpretation of Article 30. Totally ignored by Aziz Pasha. This is a 7-judge bench, my lord. There is something in the Kaveri, my lord, reference, where your lordship said, is it binding on us or is it not, my lord? I think the wisdom now is that even the reference puts points of law. Now, my lord, on 94, I come to Siddharth Pai. Give me the absolute platform.
Mr. Dhawan, my question was slightly different.
Yes.
My question was the
But
sport.
your lordship's voice is so soft.
Okay, now is it clear? Probably.
Yes,
Yeah.
much better.
Yes, okay. My question was slightly different. It arose from your argument that now for the university, a statute is required.
Yes.
Now the establishment post the independence after the 1956 UGC Act section will be under a statute. Now, when that is so, will this argument still hold good? What your argument is you're raising today? Until, because there is the legislature then who's creating or enacting the statute.
Yes, my lord.
Then will you say the foundation is not by the statute? Yes, there could be cases of colleges because colleges can be established by minorities. There's no difficulty on that. But your argument with regard to university, because it's to be established by the statute, then what will be the position?
Lord, I had indicated to your lordships that established cannot be given the narrow meaning that it's established by statute. I indicated that you had to look at origins, you had to look at nexus, you had to look at numerical. This is the criteria. Now, if you take it all into account, the question is, will the UGC Act not override Article 30? No. The fact that there is a requirement of statute will not offend Article 30. And then, my lord, as I indicated, Mr. Dwivedi was amicus, my lord, in the Yashpal order, where he said you interpret the UGC Act as by and under. So every statutory authorities, deemed universities are covered. They are under, by or under. Therefore, my lord, you cannot have a university. You cannot have a university, my lord, without degrees, without it. And therefore, my lord, you can't read down with the UGC Act, you can't read down Article 30. And then your lordships have seen in the reference in 2019, the National Minority Education Act says you have a right to a minority institution. So, my lord, your lordship's question may lead to an exclusion of tertiary education in the question of their choice comes up. I don't know if I fully answered it.
Yeah, that's right.
And my lord, the private universities have come up, all under statute.
As long as the statutes permit them, they will fall in this. That's now, if this university is set up under the statute, if the statute itself says there's a minority university, they'll obviously, because the funding is done by or the establishment is done by the minority community, and minority is a much wider term, not restricted only to religious minority.
Lord, the statute will never say.
That's where the problem will come up.
No, my lord, it doesn't come up. Because in St. David's, my lord, it is certainly true of England that you have the right to grant degrees, but you don't have it doesn't come in the Royal Charter. Your lordships will take the statute as it is and then analyze whether it's a minority institution. That is antecedent, my lord, to establish and administer.
If I may say so, brothers, establishment, if it is correlated to the statute, it's the wrong way to look at it. What the statute does is recognize, not establish.
No, I'm talking about the initial establishment.
I'm saying, brothers, establishment is not establishment through an act. Brothers, you establish something, it is recognized by the act.
So you're saying that this statute itself is a recognition of what you have.
Yeah, it's the recognition. The establishment happens. Whereas it's, how does it get recognized? Because the statute says you'll get a degree. That's the act of recognition. Without that, you won't get a degree. That's the answer.
Lord, the establishment of the fact that the statute does establishes or brings into being, which is our mother provincial. The fact that it brings into being will not militate, not under the minority right under 30. We can't whittle down Article 30 just because the statute exists. And that is, my lord, a defect in Aziz Pasha, followed, my lord, by the Allahabad High Court. Now, if I'm right, my lord, the learned Chief Justice does not want me to go into the Allahabad decision, which is under appeal before your lordships. So that would take a very long time. It's a wonderful decision, my lord, which says that dinner jackets have been exchanged for a sherwani. Great fun to read, Chief Justice Roy. Is it saffron or is it green? That's what he asks. He's moving towards.
The legislature due to oppose the constitution
arises from your lordship's query. Is 30 establishment, the term establishment, to be read in a narrow sense so that it can be taken away by statute, or in a wider sense to define what a minority institution is? The subsequent decisions of the court, my lord, say read it in the wider sense. You go back to the history, you try and figure out what the nexus is. So ultimately, if your lordships are going to give Article 30 a narrow meaning, we're back to Aziz Pasha. And everything goes through. All tertiary education cannot be minority.
At a certain level, what happens when a statute takes over an erstwhile institution, whether it's a school, a college, and gives it a statutory form? The statute really converts it into a body corporate, because what was erstwhile maybe just a society governed by the Societies Registration Act is now given the statutory character of a body corporate with a permanent seal and permanent succession. Does that conversion of a society into a body corporate, so to speak, under the provisions of the Act, deprive it of its minority character? Or is that merely only a matter of form to convert the form which was a society into a body corporate? Or does that change in form completely destroy the minority character of the institution?
Lord, our respectful submission is, it is a mandatory form, my lord. That is,
You see the long title of still remains. It's the soul of the changes. Should I put it? Objects and reasons.
yeah.
पढ़ते
लखनऊ रहने दो।
1920 का पढ़ दिया
नहीं, yes, लखनऊ का।
See.
Last place in match. My lord has spoken. Go there, my lord.
Nice, very similar to it.
No, my lord, this is a fundamental question that your lordship has to resolve. Aziz Bhasha says universities can be minority institutions. It also says they must be done by statute. And if by statute, they go. This is the unresolved question, my lord, which your lordship has to examine. And along with something which says at the end of Article 30, of their choice. Therefore, you have to read establishment as not the be-all and the end-all of Article 30. It has to be read as a whole where it says of their choice. And Aziz Pasha says your choice can be a university. And both in those days and now, my lord, if there is a statute, so will it all disappear, my lord? The entire, my lord, of tertiary education will disappear, minority institutions. And therefore, my lord, read the whole of Article 30, which is, as I've already said, my lord, the words are in Kerala University. Because the narrow, everything turns on establishment. That is why Mother Provincial says it should be to found. You take all the factors as to what is founded by the minority. It may not be in the statute. In the Delhi University case, not two cases were before the court. The Allahabad Agricultural University and St. Stephen's. And you don't find that in the statute necessarily. But you have to see who founded it. And your lordships, as soon in Patro, as soon as you say Christian, they said it's good enough to found. So don't, my lord, in my respectful submission, use established. Because as your lordship puts it, it's not a matter of form alone. It's a matter of enabling form. That enabling has to be there to come under 30. Then, my lord, we get to the questions of substance. And that is the argument, my lord, we are advancing. My lord, let me take your lords to page 94, Siddhaj Bhai.
Yes.
I'm sorry, I'm going as fast as I can, my lord. Super speed. Now, my lord, page 113. It's a 6-judge bench, my lord. Just as Kerala was a 7-judge bench. My lord, at end of the first para, Kerala education case, therefore, is not an authority for the proposition submitted by the Additional Solicitor General that all regulatory measures which are not destructive or annihilating of the character of the institution established by the minority, provided the regulations are in the national or public interest, are valid. This argument is rejected. But you go to the extreme of saying, was it annihilative? That's the wrong question. Then, my lord, the next para, the right established by Article 31 is a fundamental right in terms absolute. Now, my lord, this was tweaked by TMA Pai to say national interest must come in. But as far as, my lord, Aziz Bhasha is concerned, this was binding. Now, my lord, I come to it is intended to be a real right for the protection of the minorities in the matter of setting up of an educational institution of their choice. The right is intended to be effective and is not to be whittled down by the so-called regulatory measures conceived in the interest of not of minority, but of the public and nation as a whole. Now, this, my lord, was before the court. Now I come to the next question, my lord, which your lordship, my lord, the Chief Justice has put. That what are the implications, my lord, of the actual substance of these institutions? The implications are, it must be an institution of excellence. And this your lordship will find on page 114. This is the famous dual test, my lord, which is adopted by TMA Pi as well. Such regulation must satisfy a dual test, the test of reasonableness and the test that it is regulative of the educational character of the institution and is conducive to making the institution an effective vehicle of education for the minority community or other persons who resort to it. Now, my lord, I come to Mother Provincial, which has emphatically been accepted by TMA Pi. Understood the boss. Now, my lord, this is on page 163. And the relevant paras, my lord, which have been affirmed in TMA Pi are 8 and 9. I'll take your lordship straight away to them. Page 166. So this is actually a spy master, my lord. It's spying on what we say to each other. Now, my lord, kindly come to 8. It's very important.
You have to switch off the mic. Or tell us to switch off your mics. We have that control.
I know. Your lordship is right. Now, my lord, kindly come to 8 at page 66. Article 30, what it means. Article 31 has been construed by this court. Without reference to those cases, it is sufficient to say that the clause contemplates 2 rights, which are separated in point of time. This is important, my lord. The first right is the initial right to bring into being of an institution.
Just jump the line. First right is the.
Bringing into being of an institution.
Sorry, the first right is the initial right to establish institutions of the minority choice. Now, my lord, when we read Article 30, we don't go straight to establishment. That's a consequence. It's my right. We first, my lord, examine whether it was a minority institution or not. Then, my lord, establishment here means the bringing into being of an institution, and it must be by the minority community. The next sentence important. It matters not if a single philanthropic individual with his own means founds the institution of the community at large, contributes to the funds. The position in law is the same, and the intention in either case must be to found an institution for the benefit of the minority by a member of that community. It is equally irrelevant that in addition to the minority community, other minority or even from the majority community can take advantage of the institutions. Such other communities bring in income and they do not have to be turned away. Now come to 9. This now, my lord, I'm dealing with after Aziz Bhasha. I've dealt with before Aziz Bhasha, Siddharth Bhai and Kerala Education.
Yes.
Now, my lord, 9. The next part of the right relates to the administration of institutions. Administration means management of affairs of the institution. The management must be free of control so that the founders or their nominees can mold the institution as they think fit and in accordance with their ideas. I'm sorry, my specs are not working. Of how the interests of the community in general and the institution in particular will be best served. No part of this management can be taken away and vested in another body without an encroachment upon the guaranteed right. Now, in para 109, my lord, of TMA Pi, this is affirmed. And it's a sea change, my lord, from the establishment version, my lord, in Aziz Pasha. You first look at, is it a minority institution? Then you go further. Now, my lord, sorry. Now, my lord, if your lordships will come to 10, this is where it says such regulations do not bear directly upon management, as although they may indirectly affect. Yet the right of the state to regulate minority institutions, education standards, and allied matters cannot be denied. The minority institutions cannot be allowed to fall below the standards of excellence. Where are we here? Expected of educational institutions, or under the guise of the exclusive right of management to decline to follow the general pattern. And this applies, my lord, also to management. The university doesn't become insular. That's very important that your lordships have mentioned this. And nobody is arguing it should be insular. Then, my lord, I'll take your lordship straight away to St. Stephen's. And then TMA Pi, and I'm done with this part.
Page 380%.
Page 384.
Para 34 at page 415.
How do we approach it? It is there in Proust to some extent and Patro. But I'm coming straight to St. Stephen's. Now, my lord, kindly come to page 4.
415.
No. Please come to 413, my lord. Para 29, there's a subheading, Origins and Purpose of St. Stephen's College. I'm sorry if my reading is somewhat erratic, my lord. I'll try and be more careful. Now, my lord, Delhi University in this pleading has neither denied nor admitted the minorities of the college. Then, my lord, it says that they argued that it was done by a foreign mission from Cambridge and therefore it was not entitled to the benefit of 31. 413, page 29, para 29. Then, my lord, it goes through, and I'm not going to read it, my lord, because these are the factors that you take into account. The 81, a Christian missionary college came, members were in residence, the Cambridge Brotherhood wanted to establish a Christian college, then all that is mentioned and the condition to the contrary is therefore not correct. The purpose of starting the college, this is halfway down, my lord, of this paragraph, could be seen from the report of 1878 to Cambridge Brotherhood, and it states that the students, after leaving St. Stephen's Mission College, join non-Christian colleges and lose touch with Christian teachings. The case would be otherwise if we were to send them from our school to a college where the teachings would be given by Christians. That's at Placism E, my lord. Now come, my lord, to 31, which is important. Because these are factors, my lord. There are environmental factors, but they are important. And in Aligarh, my lord, it is writ large that this is an Islamic institution. 31 says, originally the college building was housed in hired premises paid by the SPG. A new building was eventually constructed by the Society for the Propagation of the Gospel, wherein the foundation stone bore the following inscription: to the glory of God and the advancement of sound learning and religious education. The new building was then, my lord, started in December 1881, and on the front of the porch, at the top of the parapet, a cross in bas relief was displayed, and under the brackets, and Die Gloriam, which has been inscripted since adopted by the college. Today, the new college building campus has also a large cross on top of the main tower and the rod to perpetuate and remind the students the motive and objective of the college, the glory of God. This all emanates, my lord, from found. The primary right is found. The consequential rights, my lord, are established and minister. Now, my lord, 34 sums it up. It would thus appear that since its foundation in 1881, St. Stephen's College has apparently maintained its Christian character and would be evident from its very name, emblem, motto, establishment of a chapel, and its religious instructions in the Christian chapel for religious study. This is the scope of inquiry. Now, my lord, come to 417. $41. It was contended that St. Stephen's College, after being affiliated to the Delhi University, had lost its minority character. In other words, when you come under statute under the Delhi Act of 1922, do you lose your character? But that's the statutory provision. Then it says the argument was based on some provisions of the Delhi University Act and the ordinance made thereunder. It was said that the students are admitted to the university and not to the college as such, but we find no substance in this contention. In the first place, it may be stated that the state or any instrumentality of the state cannot deprive the character of an institution founded by a minority community by compulsory affiliation, since Article 31 is a special right of minorities to establish educational institutions of their choice. The minority institution has a distinct identity, and the right to administer with continuance of this identity cannot be denied by coercive action. Any such coercive action would be void, being contrary to the constitutional guarantee. The right to administer is the right to conduct and manage the affairs of the institution. This right is exercised by a body of persons in whom the founders have faith and confidence. Such a management body cannot be displaced or reorganized if the right to be recognized is to be recognized and maintained. So recognition doesn't stand as reasonable restrictions are permissible, but regulations should be of a regulatory character and not abridge the right under 31. So, my lord, here we see the intervention of statute. As a constituent college, it was by or under the Act of 1922. Then, my lord, if I may come to page 442. 422. Para 54. The minorities were the I'm sorry, my lord, I didn't realize your lordship was conferring. The minorities, whether based on religion or language, had the right to establish and administer educational institutions of their choice. The administration of educational institutions of their choice under Article 30 means management of the affairs of the institution. This Management must be free from control so that the founders and others, nominees, can mold the institution as they think fit and in accordance with their ideas, how the interests of the rest of the community and the institution in particular will be served. Then, my lord, I would like to come. Sorry?
Standards of
Then, my lord, the next line, my lord, I'm sorry, the standards of education are not a part of management as such. The standard concerns of the body politic is governed by considerations of the advancement of the country and its people. Such regulations that do not bear directly on the management, or they may indirectly affect it. The state, therefore, has a right to regulate the standard of education and allied matters. Minority institutions cannot be permitted to fall below the standards of excellence expected of educational institutions. Now, they cite the cases, my lord, which I needn't cite, because they say this is now confirmed by a string of decisions.
Both the decision of Chief Justice Hidayatullah in Mother Provincial and the judgment of Justice Jagannath Shetty in St. Stephen's, they don't cite the judgment in Basha. They refer to all the other, because perhaps Basha in that sense is a little out of alignment with what was laid down in the other decisions. As you see, Justice Hidayatullah, that passage you read out, and actually para 54 is a restatement of what Justice Hidayatullah says in para 9 and 10.
Absolutely.
But Justice Hidayatullah refers to all the earlier cases, but doesn't refer to Basha.
Lord, Basha is referred to in St. Stephen, but it doesn't do anything to it.
Yes. Stephens refers to Siddharth by Bombay.
Para 24, page 40.
But Basha is on a fact situation.
Yeah.
I think my learned friend is arguing his case already. Now, my lord, Basha Now, my lord, kindly just turn to 410.
Hold on, hold on. What happens?
on page 410.
Page
Incidentally, it mentions it in para 24, and para 25 says it's been superseded by Patra.
Sarah?
My lord, para 24 on page 410. I won't read all of it, my lord, because this we've done. Then, my lord, 25. A couple of years after Aziz Basha, this court had another occasion to determine the nature of an ancient institution claiming to be minority. The decision, as per reported in Escopatra, since it appears to be in close parallel with the case at hand, it would be useful to have the contentions. Then, my lord, the contentions are there. And then, my lord, what happened in para 27? On appeal, the judgment of the High Court was reversed by this court mainly on two grounds. That's at page 411. The High Court did not pay sufficient attention to that part of the evidence supplied by the petitioners, which was sufficient to justify the claim that local citizens had participated in the establishment and the school in question. Indian citizenship not being a condition of the application of Article 30, the protection thereunder could not be denied on this basis. So, my lord, here we have a clear statement that if you take Patro into account, you have to look at the evidence. And this court reversed it on that basis. Now, my lord, back to
424.
may I continue, my lord?
Yes.
Page 424. Bottom of the page, paragraph 59. This is the foundation for TMA Pi 1. The need for a detailed study on this aspect is not necessary. The right of minorities, whether religious or linguistic, to administer educational institutions and the power of the state to regulate academic matters and the management is now fairly settled. So that regulation to bring it up to an excellent institution is there. The right to administer does not include the right to maladminister. The state, being the controlling authority, has the right to regulate all academic matters. Regulations which will serve the interest of students and teachers and to preserve the uniformity in standards of education among the affiliated institutions could be made. The minority institution cannot claim immunity against the general pattern or standards or general laws, such as the laws relating to law and order, health, hygiene, labor relations, social welfare legislation, contract, tort, which are applicable to all communities. So long as the basic right to management is not taken away, the state is competent to make regulatory legislation. Regulations shall not have the effect of depriving the right of minorities to educate their children in their own institution. That is a privilege which is implied by the right conferred in Article 30. 433. Now, Lord, 433, para 80.
That you're not admitting only students from your
And
own
those others who resort to it.
as the others who resort to it.
That's the important part, my Lord, of Kerala. And now here. Otherwise, what will happen, my Lord? It will become a communal institution. We don't want that. It's a kind of protection, my Lord, And I've said in St. Xavier's, it is needed there to avoid discrimination against the minorities. I won't go through St. Xavier's, my lord. It's a very long decision. Now, my lord, kindly come to 80, my lord. Broadly speaking, 80 says, reiterates Kerala Education Bill.
Right.
And therefore, my lord, now come to 88, my lord. Am I done? I have, my lord, just two more quotations from St. Stephen's, which if your lordship will indulge me, when early at 4 o'clock I will read and do TMA by tomorrow.
Yes.
Now, my lord, 88, since the receipts of a state at 435 does not impair the rights of Article 31, the state can lay down reasonable conditions for obtaining grant and aid for its proper utilization. The state has no power to compel minority institutions to give up their rights under Article 30, and then, my lord, Sadaj Bhai. Then the regulation cannot change the character of the institution. Such regulations must satisfy that dual test, my lord, of reasonableness and excellence. Reiterated here again. Now, my lord, kindly come to page 439. At the bottom of the page, para 102. Lord, may I just read it, my lord?
Yes.
Your time controllers are here, my lord.
Yes.
In the light of all these principles and factors, and in view of the importance the Constitution attached to protective measures to minorities under Article 31, the minority-aided institutions are entitled to prefer their community candidates to maintain the minority character of the institution, subject, of course, to conformity with the university standard. The state may regulate the intake in this category and due regard to the need of the community in the area which the institution is intended to serve. But in no case shall an institution exceed 50%. The minority institution shall make available at least 50%. Now, my lord, from trickling, we have now recognized 50%. Of course, TMIP says it depends on the nature of the institution.
Just read the last but one sentence once again.
Sorry, my lord.
Just read that last but one sentence, paragraph 102. The state may regulate.
The minority institution shall make available that.
Yes, yes.
At least 50% of the annual admissions to members of communities other than the minority community, the admission of such minority community candidates shall be done perfectly on the basis of merit. Of course, in St. Stephen's, they said you can do an interview, which was crucial. Delhi University said you can't do an interview. And although it was a
Yes.
it is.
So please don't comment upon it.
So, my lord, I will stop here if I may. And thank your lordship for your gracious acceptance of my taking the chair.
We'll reassemble tomorrow morning.
Thank you. 45.